It's 9:30 by that clock, a few minutes after because of mine, and we want to open the hearing and welcome our members of our panel, first and only panel. Before I do that, I want to take a point of personal privilege on behalf of my colleague, Mr. Bass, who sends his regrets that he wasn't able to be here. He serves on the subcommittee as our panelist from the state of New Hampshire knows that there was a tragedy and a loss of a chief of police in Greenland, New Hampshire. He was killed in the line of duty last Friday, so much of the New Hampshire delegation is up there with a lot of state and local officials today, and that's why Mr. Bass cannot attend, and as a member of the subcommittee, is a very active member. So with that, I'd like to just pause for a moment of silence in remembering the law enforcement community and Chief of Police Michael Maloney and his family and the entire state of New Hampshire. Thank you. And now I'd like to recognize myself for 5 minutes for an opening statement. Today, the subcommittee will hold a hearing on H.R. 4345, the Domestic Fuels Protection Act of 2012. I am proud to once again be a lead sponsor of this bipartisan legislation with my colleague on the committee, Mr. Ross. This Congress, I am pleased also to welcome in this Congress Congressman Sullivan, our Vice Chairman on the Energy Subcommittee, as well as Colin Peterson, a ranking member on the Ag Committee, as original co-sponsors. In some shape or form, everyone is affected by the increase in gas prices. Whether it is a seasonal price spikes we are now starting to see across the country or the overall higher prices at the pump the last couple years, Americans are looking for ways to bring down these costs and break our dependence from hostile sources of foreign oil. Some see the path forward through renewable fuels like ethanol and biodiesel, which are providing both lower prices at the pump and less dependence on oil. Now we are also waiting for the next generation of cellulosic ethanol and biofuel products to come online and create an even more renewable fuel right here at home. Others recognize the promise in our natural gas reservoirs throughout the country. In fact, we had an interesting debate about that just 2 days ago in Chairman Whitfield's committee about our ability to convert this abundant natural resource into a liquid natural gas for transportation fuel could provide yet another significant and inexpensive alternative in the marketplace. I support an open fuel standard that would break our mandate on gasoline by requiring cars and light-duty trucks to operate on a variety of different fuels. This will allow all fuels to compete in the market, and from there, consumers can choose the fuel for their vehicle based upon factors important to them, such as price and miles per gallon. And I hope my colleagues on this committee and the full committee will give that piece of legislation serious consideration. However, the legislation we are discussing today is not about these or any one fuel option at all. H.R. 4345 would apply to any new fuel or fuel additive approved and registered by the EPA. H.R. 4345 is needed because EPA approved up to 15% ethanol blends only in vehicles whose model year is 2001 and newer, in essence bifurcating the vehicle market. The practical result of EPA's action has been that a morass of pending legal liability and uncertainty have frightened the market and complicated the supply chain's ability to provide a means of delivery for the new fuels. We will hear today from a retailer community prepared to comply with regulations to legally distribute fuel, yet still be subject to lawsuits if a consumer misfuels their own vehicle. Similar uncertainty exists for other parties in the supply chain, and they are here to discuss whether this serves as an unavoidable barrier to entry. We need to find out what the specific problems are so the final product of this bill can address them in the most appropriate and targeted way. The intent of H.R. 4345 is to ensure any party that is compliant with EPA fuel regulations is not subject to litigation based upon those merits alone. As a main sponsor of the bill, I can assure you H.R. 4345 is not an attempt to allow parties to abdicate any of their responsibilities. I do not intend this bill to relieve parties who acted negligently from liability in the court. Nothing in this bill would remove responsibility for environmental cleanup under RCRA, Superfund, or any other federal or state law. If an underground storage tank containing any fuel were to have a leak, the owner or operator will be liable the same way they are today. H.R. 4345 simply clarifies that just having a registered fuel in a tank EPA has determined compatible does not automatically put you in violation of the law. The purpose of this legislative hearing is to hear comments on the bill, including suggestions on how to approve it. One of our witnesses suggested that H.R. 4345, as introduced, somehow blocks legal actions arising from mishandling of MTBE going back to the days when MTBE was used as an oxygenant instead of ethanol. Frankly, I like ethanol as an oxygenant better than MTBE anyway, but that's a debate we've had numerous times, Mr. Green. This is certainly not the intent of the legislation, but this really is the reason why we have hearings. And so we're going to hear from our member from New Hampshire on the panel, and he's raised some good issues that we need to address. Also, my colleague, as I mentioned earlier, and member of the subcommittee, Mr. Bass, has spoken to me personally on this issue because it is a pressing issue for the state of New Hampshire. I appreciate his commitment to work with me in moving forward to ensure H.R. 4345 does not infringe upon ongoing litigation and cleanup in his state involving MTBE. H.R. 4345 will allow a critical path forward now and into the future to ensure consumer access to new transportation fuels competing in the market to drive costs down. I want to thank the witnesses for being here today to give their perspective on the bill. I look forward to their testimony and willingness to answer questions to help us as we work to move this legislation forward. With that, I'd like to now yield to the ranking member of the committee, Congressman Gene Green from the great state of Texas.
Thank you, Mr. Chairman, and you and I have debated the difference between MTBE and ethanol, and obviously we lost that battle in the Senate in 2005, but like the Battle of San Jacinto, I don't mind bringing it up all the time. But first of all, before I go into my statement, I'd like to introduce to you and our staff, my staff member is handling the committee is Lindsay Westfield, who actually, those of you remember a few weeks ago in a full committee markup, I had a great staff member, Abigail Pinkley, who actually worked in our office for many years and was LD and went downtown, so to speak. I know Congressman Murphy, and I know she went to work for the National Association of Community Health Centers, which we work with a lot. But Lindsay will be doing the staffing on the committee, and Lindsay's been in our office. In fact, started literally at the front door, and for many years, and I appreciate her working, sitting in on this and doing energy and environment work on our staff. Mr. Chairman, I want to thank you for holding the hearing today on H.R. 4345, the Domestic Fuels Protection Act of 2012. This is an issue that's I've been actively involved in for a few years, and I'm pleased the committee is giving this important issue the attention it deserves. We have a serious problem coming down the pike, and we have sat on resolving this issue for too long. As the EPA continues to approve and register new fuels and fuel additives needed to comply with the renewable fuel standard, this problem will only grow as refiners will have to increase the ethanol content and shrinking volume of gas. The use of renewable fuels such as ethanol in domestic fuels is not a matter of choice by the private sector. Rather, it's mandatory as a result of the renewable fuels mandate established in Section 211 of the Clean Air Act. If Congress wants renewable fuels to be part of the fuel supply, private sector fuel refiners and manufacturers must be willing to produce these fuels. However, holding these private entities liable for fuel formulations mandated by the government creates a disincentive for private companies to participate in the renewable fuels program, which would undermine the Clean Air Act goal of increasing the use of these renewable fuels. So, Mr. Chairman, again, I appreciate your looking into this issue. Unfortunately, I have serious concerns about the approach H.R. 4345 takes, and do not think this bill appropriately addresses the problems. Fuels and fuels additives can pose risks to automobile equipment and equipment safety, air quality, groundwater, and land. That's why states, localities, and federal agencies have taken action under various statutes to try and mitigate these risks and protect human health, safety, and the environment. H.R. 4345 would preempt and eliminate the vast majority of these requirements, leaving states and municipalities and property owners without protection from or remedies for the damage to their personal effects and potential contamination of our groundwater. To put it into perspective, I can't imagine anyone in this room would be okay in not having any sort of recourse if your engine is ruined from an accidental misfueling. That's why for two Congresses I've been a strong supporter and co-sponsor of our fellow Energy and Commerce member, Representative Gonzalez, American Fuel Protection Act, H.R. 523. This reasonable bill would waive the sovereign immunity of the federal government and allow for lawsuits involving the use of ethanol and renewable fuels to be brought exclusively against the federal government. Providing this remedy would allow for the redress of legitimate damages without punishing our manufacturer distributors who are simply complying with this federal government mandate. Importantly, too, any damages awarded for such a claim would not exceed the actual damage sustained by the plaintiff. When the government requires the manufacturers to produce products in the specific formulations, the government should be responsible for the liability risk associated with these formulations. And with this bill, everyone in the transportation fuel chain can rest assured they do not have a fear of litigation for complying with the government mandate, while also not depriving plaintiffs of their day in court. It's a matter of fairness, Mr. Chairman. I look forward to working with you and resolving my concerns with H.R. 4335 and addressing the issue. And I'd also like to submit 3 letters for the record. One from the Boat USA, Boat Owners Association in the United States, the American Automobile Association, Public Affairs, and also the American Waterworks Association. I'd like to submit them for the record.
Without objection, these letters will be submitted for the record.
Back my time.
If I can just claim your remaining 30 seconds, I just want to give an anecdotal story of I won't name my staffer who years ago drove up to a filling station and put diesel in the gasoline engine of a vehicle. Obviously, he was the one who was negligent and didn't read the pump. We all know diesel pumps are labeled properly, and who had to pay for the cleanup or the repair. It was the person who was negligent in misfueling the vehicle. And so that basic premise is really the same thing here. We didn't go back and sue the retailer, nor did we go back to the refinery and sue them for producing a product that I shouldn't have, or my staffer shouldn't have put in the tank to begin with. We had to bear the brunt of that mistake. And I think that's really the basic premise of what we're trying to do. Thank you for the time.
Mr. Chairman, could I just respond?
Yeah.
I have a 2002 Chevy Blazer, and if I don't put diesel in it, but if that engine is hurt by requiring 15% ethanol as compared to 10%, that's the only option I have when I go into one of our service stations. So I think I agree. If I do it wrongly, if I put diesel or something in a vehicle or someone else does, that's, but when you don't have a choice and the government mandates that, the government didn't mandate that diesel fuel. I yield back my time.
You must not trust the EPA. You know I do, don't you? I'd like to yield now to the chairman of the full committee, Mr. Upton, for 5 minutes.
On that note, as you and I were both staffers, so protect our crew or ourselves, thank you for holding this hearing. We know that transportation fuel is varied and changing in the country, and part of the reason why is because of federal mandates that are enacted and expanded the last number of years. A number of years ago, gasoline blended with 10% ethanol was hard to find outside of the heartland, but now it's really just about everywhere. And EPA has recently approved the E15 blends with up to 15% ethanol, but not for everyone. Not for cars older than model year 01, not for boats, lawnmowers, chainsaws, other small engines. And that's just a snapshot. As the renewable share grows under the RFS, we're likely to see more varieties of fuels and fuels blending seeking EPA approval. All of these changes, which are coming as a result of the federal policy, have to be dealt with. The market wants and deserves some measure of certainty for sure, not price guarantees or supply quotas, just some confidence that if you refine, distribute, blend, or dispense transportation fuel and you follow all of EPA's rules, you're not going to face legal risks for doing that. H.R. 4345, the subject of today's hearing, does 3 main things. First, it says no one will be held liable because of a storage tank or fuel dispensing equipment not compatible with a particular fuel after EPA says it is compatible. Second, it says that no person is liable because a self-service purchaser fills up with fuel not approved for their car or other engine. That's just common sense, like saying the retail store that sells you antifreeze is not liable if you take it home and drink it, or you put diesel fuel in your car that's not supposed to go there. Third, it ensures that people who design, make, sell, or distribute any fuel, vehicle or engine, doesn't face lawsuits resulting solely from the fact that an EPA-approved fuel goes into a vehicle or engine. So let's be clear on what the bill does not do. does not change fuel retailers or anyone else's environmental cleanup obligations under RCRA or Superfund. It does not excuse unfair trade practices or anti-competitive behavior. And it does not say people who act negligently are not held accountable. Instead, it says that following EPA regs and selling EPA-approved fuel is not enough to get you into trouble. And I would yield to any of my Republican colleagues seeking time.
Mr. Cassidy, were you looking for time for an opening statement? Anybody desiring time? If not, Chairman Years back. I've been asked by the minority to allow Chairman Waxman, when he arrives, to give his 5-minute opening statement. I think I'd like to do that if there's no objection. Hearing none, then we'll move to our first panel. We'll briefly introduce you all, and then we'll go. Most of you are experienced here. Your full statement submitted for the record. You have 5 minutes. From my left to right, we have John Eichberger, Vice President of Government Affairs, National Association of Convenience Stores. Next, we have Charles Drevna, President of American Fuels and Petrochemical Manufacturers. Gene, I want you to listen to his testimony carefully.
I've reviewed it.
Bob Deneen, President and CEO of Renewable Fuels Association. Shannon Baker Brandstetter, who is the Policy Council, Energy and Environment Consumers Union Policy and Action from Consumer Reports. And Kay Allen Brooks, Senior Assistant Attorney General and Chief Environmental Protection Bureau from the state of New Hampshire. We want to welcome you all. We'll start with Mr. Eichberger. You're recognized for 5 minutes for your opening statement.
Thank you, Chairman Shimkus and Ranking Member Green. I appreciate the opportunity to be here to explain why NAC supports 4345. The convenience store industry operates 149,000 stores in the nation, of which about 121,000 sell fuel. Through these stores, our industry sells about 80% of the gasoline consumed in the United States every year. This puts retailers right in the middle of policies and consumers when we're trying to bring them to market. Our reasons for supporting 4345 are actually quite simple. As we look into the future of the motor fuels market, we know new fuels will be developed. The renewable fuel standard makes this an absolute certainty, as Chairman Upton mentioned. New renewable fuels must be brought to consumers. As these fuels are approved and consumers begin to ask for them, NAC's members want to satisfy consumer demand and offer these fuels. If they are not able to do so, it is likely that the goals Congress set when it established the RFS will not be met, which is precisely why 4345 is important. First, and I think it's important, our members want to be responsible retailers. They take very seriously their role to protect the environment and prevent releases. Some of you were on the subcommittee when it considered the Energy Policy Act of 2005. And you may remember that NACS was the strongest advocate supporting increased enforcement of underground storage tank regs. We pushed for legislation to require inspections, operator training, and shutting down non-compliant tanks. Our commitment to ensuring the integrity of our tank systems has not changed. If you think about it, this makes sense. Convenience stores are part of their communities. In fact, 58% of the stores that sell fuel are one-store mom-and-pop operators who probably live right around the corner from their store. They live in the communities they serve, and they don't want to pollute or tarnish their reputation. They care about the communities. Not to mention, if they have a release, it's extremely expensive to clean it up, so their commitment to making sure that the stuff they put in their tanks does not release is absolutely pure. Retailers are also reluctant to spend maybe $100,000 to replace equipment that is perfectly suitable for the fuels they want to sell. And that's where 4345 comes in. The bill will establish a mechanism for retailers to determine if their existing equipment is safe and compatible to dispense a new fuel. That's it. 4345 says if the equipment is technically safe and compatible, it should be legally recognized as safe and compatible. If the equipment's not compatible, retailers are going to have to replace it. And that's the bottom line. We don't want to use non-compatible equipment, but we shouldn't have to replace equipment that is compatible. It's that simple. There is nothing in this bill that changes a retailer's responsibility to prevent releases or to clean up any contamination that results from a release. It simply gives them a legal mechanism for determining if their equipment is compatible. The other main reason our members support this bill is to ensure there's a clear set of rules by which they must operate and some reasonable legal protections for them when they do comply with the rules. 4345 addresses this in two simple ways. One, if EPA approves a fuel for only a subset of engines, the bill requires EPA to issue regulations to prevent misfueling. The bill does not dictate what these regulations must say. EPA may determine that labels are all that's necessary, or it may require nozzle and fill pipe restrictions, or it may even require that the fuel be sold behind a locked cage. Whatever the rules, retailers will comply. And those rules can be determined through the agency rulemaking process. Once those rules are established, if retailers do comply, they want to know that if someone else circumvents those rules and those misfueling provisions, they're not going to be held responsible for that other party's actions. They do not believe they should be held accountable for actions that are beyond their control, and 4345 provides them that protection. And then, once a fuel is approved and the rules governing the sale of that fuel are established, retailers will comply. If the rules change or a fuel is removed from the market, retailers will adapt and comply with the new rules. That is only reasonable, and we do that all the time. However, my members do not believe it is reasonable to hold them accountable to comply with a regulation or a rule that does not yet exist. Basically, our members say, tell us what we have to do and we will do it. But don't turn around and punish us for someone else's behavior or hold us responsible if you later change the rules on us. You have to give us an opportunity to comply with the new rules. 4345 is a reasonable and limited bill that provides certainty to the market. This is why NACS members support the legislation. I urge the committee to proceed with consideration and enactment of this bill to provide the market with the certainty it needs to bring innovative fuels to the market. Thank you. I look forward to your questions.
Thank you. And now I'd like to recognize Mr. Drevna for 5 minutes. Thank you. And your opening statements in the record. You have 5 minutes.
Chairman Shimkus, Ranking Member Green, and members of the subcommittee, thank you for giving me the opportunity today to testify at this hearing on the Domestic Fuels Protection Act of 2012. Charlie Drevna, and I serve as AFPM's president. AFPM is a 110-year-old trade association that was formerly known as the National Petrochemical and Refiners Association up until this year. AFPM members use oil and natural gas liquids as raw materials to manufacture virtually the entire supply of U.S. gasoline, diesel, jet fuel, home heating oil, and other fuels, along with petrochemicals used in thousands of products. We support the Domestic Fuels Production Act. Now, as we have stated for years, and it comes no surprise to this subcommittee or any committee in this Congress, we oppose subsidies and we oppose mandates. We continue to have serious questions about the workability, structure, and unintended consequences of the existing renewable fuel standard. However, as long as the RFS remains the law, and it is the law of the land today, our members must work to comply with its requirements. The Domestic Fuels Production Act would provide the necessary legal certainty for all parties in the transportation fuel supply chain. This is critically important as the Environmental Protection Agency approves and registers new fuels and new fuel additives needed to comply with the ever-expanding RFS. Under the RFS, 36 billion gallons of renewable fuels must be available in the U.S. marketplace by 2022, 10 short years from now. That's a dramatic increase from the 13.7 billion gallons of renewable fuels available last year. With rising mandates, falling demand, refiners are required to increase ethanol content in a shrinking volume of gasoline. However, the refining industry is only one of several domestic industries that will have to address these challenges. Engine manufacturers, as well as transportation fuel providers, all face challenges posed by the need for alternative fuels under the existing RFS. Our challenge, again, as long as the RFS is the law of the land, is to integrate these new fuels into the fuel supply. All parties in the transportation fuel supply chain need to know they will not face the blizzard of unwarranted litigation simply for complying with the law that Congress deemed necessary. The Domestic Fuels Production Act provides such certainty. Companies that use, manufacture, and sell transportation fuels that meet government-approved, government-mandated specifications and standards should not be punished for doing so. The Domestic Fuels Production Act accomplishes that goal, and we urge Congress to act on this important legislation. Thank you, and I'll be happy to respond to any questions you may have.
Thank you. Next, I'd like to recognize Mr. Deneen, and you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, Ranking Member Green, members of the committee. I appreciate the opportunity to be here today to speak in support of H.R. 4345, the Domestic Fuels Protection Act. I got to tell you, I think this is an important hearing and it's an important time because consumers are facing rising gasoline prices. And if we do not find a way to reduce our dependency on imported oil, we're going to continue to suffer the consequences. At the outset, I must note that this committee has already put in place a program that is today reducing our dependence on imported oil, creating jobs and economic opportunity across rural America and reducing gasoline prices at the pump. That program is the Renewable Fuel Standard, and that program is working. Consider these facts. In 2005, when the RFS was adopted, the U.S. imported more than 60% of our crude oil and petroleum products. Today, in large part because of the RFS, we are just 45% dependent on crude oil imports. Now look, it's clear that increased domestic oil production and increased efficiency have played a role in that success as well, but consider this. Since 2005, 81% of the increased domestic fuel production in this country has been ethanol. 8 out of every 10 new gallons of fuel produced in this country has been ethanol. That's the success of the RFS. That is the success of ethanol. Now, as the ethanol industry has continued to grow, indeed, the economic footprint of the industry has just gotten better as well. The 14 billion gallons of ethanol that were produced and used in this country last year created some 400,000 jobs. We added $43 billion to GDP, $30 billion to household income. That is a success that is being felt all across America. But perhaps most importantly, as consumers continue to face skyrocketing gasoline prices at the pump, is that ethanol is lowering the price consumers pay at the pump today. 2 reasons for that. Ethanol today is $1 cheaper than gasoline. So you're adding 10% ethanol today, hopefully 15% very soon. It's going to reduce consumer gasoline costs commensurately. But also, because ethanol is now 10% of the nation's motor fuel supply, we are reducing the demand for imported oil, and that is having an additional economic benefit for consumers. A study that was done last year said that the ethanol produced in 2010 reduced gasoline prices by 89 cents a gallon. That's a real benefit to consumers. That's a real benefit of the RFS. So I can say without hyperbole or reservation that the RFS has been the most successful energy policy this nation has ever implemented. It should be vigorously defended and maintained and allowed to reach its full potential of 36 billion gallons in 2022. But the RFS is entering a critical period. The volumes of renewable fuels refiners are required to meet can no longer be met just by 10% ethanol. Greater volumes of ethanol and a greater diversity of biofuels and feedstocks will be necessary to meet the increasing volumes required by the RFS. Critically, these fuels will be attempting to enter the marketplace amidst a complicated regulatory structure that favors incumbent technologies and discourages market access. Gasoline marketers deserve the certainty that they will not be penalized for utilizing a new fuel or fuel blend that has been approved for use by EPA. H.R. 4345 supports the RFS and facilitates the introduction of additional volumes of renewable fuel by assuring gasoline marketers don't need to replace perfectly good underground equipment and above-ground dispensing apparatus to market renewable fuels. The current regulatory structure provides no pathway to certify existing equipment for anything other than fossil fuels, even when test data demonstrates its safety. The Domestic Fuels Protection Act allows EPA to create such a process, thereby providing new fuels access to the marketplace without having to expend time and resources on new infrastructure unnecessarily. The bill also provides assurances to retailers that they won't be subjected to frivolous lawsuits when they have abided EPA regulations. The legislation is narrowly tailored to achieve this goal. In sum, the RFA supports H.R. 4345 because it is consistent with the goals of promoting energy independence through the increased use of renewable fuels as outlined by the Energy Bill. The Domestic Fuels Protection Act would eliminate technical barriers and speed the introduction of new fuels that can help decrease our nation's reliance on oil and lower gasoline prices. Chairman Shimkus, you've made a real commitment to the growth of this industry with your support of this legislation, with your support of the Open Fuel Standard, which we also support, and I look forward to working with you and the rest of the committee to move this legislation forward. Thank you.
Thank you very much. Now we'd like to recognize Shannon Baker Brandstetter. You're recognized for 5 minutes.
Thank you. I'm pleased to be here today representing Consumers Union, the public policy and advocacy arm of Consumer Reports. My comments today are also supported by Consumer Federation of America. Consumers Union opposes the Domestic Fuels Protection Act of 2012 because it would unfairly burden consumers by shifting the risks of fuel-related damage entirely onto consumers. This bill uses EPA's waiver authority under the Clean Air Act as a shield against consumer product liability, which would leave consumers solely responsible for damage caused by E15. In addition, the bill provides sweeping immunity for a broad array of fuel-related damage to consumer equipment and underground storage tanks, and any resulting leakage that can devastate drinking water supplies. State consumer protection law is still essential to protect consumers from marketing and selling fuels or additives in a manner that is likely to cause damage to consumers' vehicles and equipment. But this bill preempts these important state protections. EPA's approval of a fuel or fuel additive has little to no bearing on whether the fuel will damage consumer products. And EPA is in no position to determine the scope of a fuel's effect on consumer products outside the emissions context. EPA's approval does not imply that as a product, the fuel or fuel additive will not pose other risks for consumer products. Immunizing fuel providers and vehicle and equipment manufacturers from responsibility if something goes wrong, as this legislation would do, leaves consumers squeezed in the middle. If auto manufacturers are allowed to void warranties and fuel providers are also immune from liability, consumers will be left to foot the bill for any damages caused by E15 or other fuels. In the case of E15, Consumers Union does not believe that the EPA label on misfueling goes far enough to prevent consumers from unintentionally misfueling. And we are not alone in this belief. Gasoline retailers, petroleum producers and marketers, and associations representing automakers, outdoor power equipment, and marine engines all stated unequivocally in their comments in last year's rulemaking on misfueling mitigation that despite the EPA label, consumers will misfuel and the resulting damage could be significant. That appears to be the reason behind the industry seeking immunity from liability. Unfortunately, the proposed legislation, rather than trying to solve the problem of preventing damage from E15 and easing its transition into the marketplace, would simply sweep aside all liability from E15 for everyone but the consumer. Our organization does not want to encourage lawsuits, but we do want to encourage responsible behavior in marketing and informing consumers about E15 and selling transportation fuels more broadly. We hope shared responsibility will actually stave off lawsuits. Some level of misfueling is inevitable, but fuel providers should do all they can to minimize misfueling and ensure the safety and suitability of fuels they bring to market. By sharing responsibility for the fuels they sell, fuel providers will be motivated to enhance safety, minimize consumer confusion, and help consumers select the proper fuel. EPA labeling is useful and cost-effective, but it is not sufficient to prevent misfueling by consumers with resulting damage to older vehicles and non-road engines. Fuel providers are in the best position to provide tailored warnings, labeling, or other forms of education to consumers to prevent misfueling at the point of sale. Removing liability beyond posting the EPA label will decrease the motivation for adopting such techniques. Fuel providers know their clientele best and can proactively help them avoid engine damage. Consumers Union wants to encourage retailers to adopt local solutions to help reduce misfueling. Our suggestions include iconic labels on gas pumps to identify non-compatible products, dispenser prompts confirming E15 purchases, as well as separate dispensers for non-vehicle fueling. There are numerous other signage, outreach, and station configuration options that would help customers avoid misfueling. But the extension of immunity would likely undermine the incentive to maximize such measures. In conclusion, E15 retailers, fuel providers, marketers, state and federal regulatory agencies, and consumer protection offices should all work together to inform consumers of allowable uses as well as risks of E15. This bill shifts the risks and costs associated with E15 misfueling onto the shoulders of consumers and releases many industries from acting responsibly in marketing and selling transportation fuels. Thank you for your attention to consumer concerns. I'm happy to answer any questions.
Thank you very much. Now I'd like to recognize Mr. Brooks for 5 minutes.
Thank you, Mr. Chairman. Thank you for allowing me to testify today on behalf of the Office of the Attorney General of the State of New Hampshire. Before I begin my comments, I would like to specifically thank the Chairman for his comments earlier about our existing MTBE case, and as reflected by Representative Bass, we do truly appreciate that. It's left me somewhat despondent because now I have a lot less to complain about, but I'll do the best that I can in the time that I have. When we do work together on making this bill something that we can live with, we are very concerned about Section 4A, as you may well imagine. we understand that the purpose as set forth today and as reflected by some panel members is to protect essentially those people who are innocent, who are simply complying with the law from facing liability. We have no issue with that. Anyone who is familiar with our MTBE lawsuit knows that we didn't sue any station owners. We didn't sue any convenience store owners. We were looking for redress from the people that we thought actually had a role and could have prevented the harm. In fact, it's our intention that a portion of whatever recovery we get go to actually help those convenience store owners clean up their property. So we take no issue with that, but we do believe that the existing Section 4A as written is too broad, and whether that's MTBE or maybe whatever the next equivalent of MTBE is, that we do need to work on this. It doesn't appear to account for the behavior of the defendants in any particular case, and that's the troubling part. So again, I believe that with some work through Representative Bass, perhaps we could address some of those issues, and I do appreciate that opportunity. And with respect to our existing MTBE case, we do feel it has to be absolutely clear that it does not impact those types of litigation, and perhaps our case specifically as one of the, probably one of the biggest in the nation right now. Section 4B, which is what it's called the safe harbor provision, is also troubling, at least in its current form. It's not entirely clear what retroactive application this may or may not have, but any lack of clarity is a problem for us. When you have defendants that have significant means, they are able to raise any issue they possibly can. Anything that becomes a source of delay to a small state like New Hampshire can be a considerable burden. We only have 1.3 million people. Our MTBE lawsuit alleges that 1,551 sites are currently contaminated with MTBE. 40,000 private wells are probably contaminated with MTBE, as well as hundreds of public water systems. The cost of that cleanup is hundreds of millions of dollars. That's hundreds of dollars for every man, woman, and child in New Hampshire. That can't be borne by the taxpayers. Specifically, Section 4B, the safe harbor provision, talks about that nothing that essentially is approved by EPA shall become a defective product. I understand, at least tacitly from what I can gather, that maybe the focus of that is on strict liability claims, claims for people who haven't acted negligently, and specifically for store owners and the lower station owners. Again, we don't necessarily have an issue with the store owners, but first of all, there are circumstances where the type of strict liability claim has merit, and someone who had the ability to efficiently resolve a problem is in a better position to face that type of liability. But I would point out also that a defective product doesn't necessarily only apply in strict liability cases. There are negligence cases where you can say someone was negligent by introducing a defective product. It appears from the language that this may affect somehow those types of claims, and certainly we would want to work with you to make sure that that didn't happen, especially if that was an inadvertent consequence. Briefly, with respect to the USTs, New Hampshire has a very robust program for monitoring USTs. We've recently taken care of every above-ground storage tank in the state in terms of regulatory compliance, which was a massive undertaking. We're now focused on USTs, and I think that the state has done a very good job. There are some things that we wonder under this bill whether New Hampshire could continue to do, and just how broadly that immunity would sweep. For instance, I was alerted very recently that there are these things called yellow pipes, essentially connectors between UST tanks and other facilities. These tanks may have been approved by either EPA or UL at some point. They may be compatible at the time they're in, but we have a program that monitors throughout time. So if in 20 years they're degraded and we tell someone to fix it, we expect it to be fixed and not have someone come back and say, well, that's on the approved list, so go away. So that stands true for much of our program. Again, we look forward to working with you on these issues, and I'm sure we'll be in contact with Representative Bass, and I really do appreciate the opportunity to speak today.
And we welcome you, so thank you. Now I'd like to turn, as I mentioned earlier, to the Ranking Member of the Full Committee, Mr. Waxman, so he has time to do his 5-minute opening statement.
Thank you, Mr. Chairman. I want to thank our witnesses today for their presentations. I know that, Mr. Chairman, you indicated you're going to be changing some of the drafting of the bill. You saw some of the drafting was flawed, and you particularly commented about changes in the MTBE area for contaminated drinking water supplies. I appreciate that. But I think that this bill is flawed beyond just the drafting. With all due respect, the flaws of this legislation would eliminate all recourse for communities that have lost their drinking water supply to MTBE contamination. There are over 1,500 registered fuels and almost 7,500 registered fuel additives. This legislation would remove all liability for harm caused by these fuels and fuel additives. Some of these additives are rarely used because the oil companies understand that they're powerful contaminants, and if they enter the groundwater, they could do harm. They can damage small engines. They can cause impact on public health. We don't know on this committee the facts for each of these 9,000 fuels and fuel additives, but under this bill, oil companies can now use them with impunity. Consider ETBE, which has many of the same chemical characteristics that have made MTBE such a difficult contaminant to clean up. This bill would exempt oil companies from liability for ETBE contamination. MMT is a fuel additive. It can severely damage engines and potentially endanger the public health. We should not eliminate liability caused by MMT, but that's what this bill does. MTBE rarely contaminates water by itself. It's usually part of an underground plume of gasoline from leaking underground storage tanks. If we remove the liability shield for MTBE, what about the other constituents in gasoline, such as benzene, that can also contaminate a community's water supply? I certainly welcome greater clarity from the chairman on how he plans to modify the bill. But the point is to have this committee pick and choose among the 9,000 fuels and fuel additives, providing liability protections for some and not others, sounds like the ultimate case of government picking winners and losers. If we exempt all of these 9,000 fuels and fuel additives, we're not picking winners and losers, except we're picking the losers, because one point is for sure is that if we pass this law and absolve ExxonMobil of any liability for selling unsafe, dangerous, or defective fuels, we'll remove the incentive for responsible corporate behavior. There are many other reasons why this legislation, I believe, is pretty bad. Section 2 provides that if a convenience store owner determines that his or her underground storage tanks are compatible with a fuel, then the owner is exempt from liability if he leaks pollution, if his leaks pollute the neighbor's drinking water. Section 3 says if someone sells you fuel that damages your car or destroys your boat engine, well, you're on your own. Section 4 has a safe harbor provision for all fuels and fuel additives that's similar to the one that Representatives Barton and Bass proposed for MTBE in 2005. Safe harbors for the future, but protected New Hampshire's lawsuit on MTBE when it was offered in 2005. It said other states couldn't engage in lawsuits. And then it adds a provision to throw out civil actions that are already in court. And on top of that, it prohibits even filing certain civil actions, making it against the law to turn to the courts for justice, runs contrary to our basic values. I may be making some factually incorrect statements because the chairman is revising his bill, but the essence of this bill is to provide exemption from liability. And I'm troubled by exempting from liability people who ought to be held accountable. This is, I think, Washington at its worst. There are trade associations that couldn't agree on this bill. There are real challenges associated with implementing the renewable fuel standards mandated by Congress, but the only thing these trade associations could agree to is to shield themselves from any liability and shift the costs of harm from their product to the consumers or to the taxpayers. And this is not going to solve problems. It's only going to enhance our problems. Mr. Chairman, I regret to say that I have such troubles with this bill. I still hold out the chance that we could work on a bipartisan basis on some of these issues, like reauthorizing our Safe Drinking Water Acts, state of revolving loan fund. That needs to be reauthorized. It should be done in a bipartisan manner. I'm disappointed that we've gone in the opposite direction with this legislation. Rather than working to ensure our communities have safe and affordable drinking water, we're considering legislation to allow oil companies and others to pollute groundwater with impunity. That's very disturbing to me, and I hope that my worst fears are not going to be realized. Yield back my time.
Thank you, Mr. Chairman. I always say that elected officials need to take big doses of humble pie and humility, and you continue to offer me a humble position, and that's a healthy thing in our process. So I'm glad we got you with your opening statement. I'd like to recognize myself for 5 minutes for questions. Mr. Brooks, I do appreciate this. We haven't really talked MTB in this committee in a long time, so I think your concerns took a lot of us by surprise, and I do. So with respect to that, and that's why you have hearings. We have hearings to address concerns, get input, and try to adjust legislation, because it's really in the intent to move something forward, to really, if the Environmental Protection Agency and federal policy, which we passed not just in the 2005 energy bill, but we expanded it in 2007. 2005, Republicans were in the majority. 2007, Democrats were in the majority. And we continued to move the SRFS forward, which is the national policy. So a legal fuel being administered by a local retailer, maybe a family-owned, I mean, the major premise is they shouldn't be harmed by doing what the law is forcing them to do. But if you could help provide us summaries of your claims in the state actions on MTBE and underground storage tanks, so we can exactly see what the basis of the lawsuits are, we would appreciate that. I think that would help us. Also, if you could summarize the defendant's responses, that would help us in trying to go back to our legislative council to try to address these concerns. Would you be willing to do that as we move this legislation forward?
Would you like me to do that now, or just to work with Representative Bass and others on that issue?
We can work with the committee and Representative Bass, and that would be helpful. Most people should know that we've just been called for votes. Of course, we got 15 minutes to get to the first vote. We'd like to get through at least my opening questions, maybe Mr. Green's, and then we'll then adjourn and come back, and we'll have plenty of time to finish up afterwards. This question is to Mr. Eichberger, Mr. Drevna, and Mr. Deneen. Do you think this legislation prevents federal agencies besides the EPA from issuing or enforcing regulations?
I do not, Mr. Chairman. I think the legislation basically sets a precedent that as long as we're complying with the regulations that are applicable, then we have some reasonable protections under law.
Mr. Drevna?
I agree with Mr. Eichberger, but the thing is we have to make sure those regulations are tested. We have to make sure the fuels are tested. We have to make sure there is consumer protection before entering into any marketplace.
And Mr. Deneen?
I agree that with the assessment that this does not prevent other agencies from implementing new regulation.
Does it affect OSHA in their involvement in safety and health issues?
No.
Mr.
Not in the
Drevna? Mr. Deneen?
Let the record show that Charlie and I agree again.
It's a scary day. What about the Consumer Product Safety Commission? Does this legislation affect any actions that the Consumer Product Safety Commission might be involved with?
Not to my knowledge, no.
Mr. Drevna?
Not in my reading of the bill, sir.
Mr. Deneen?
No, sir.
It's a hard time. Ms. Brandstetter, Baker Brandstetter, do you agree with those summaries of not impacting federal regulatory agencies to do the job that they're required to do, and CERCLA, RECLA, and all the other federal laws and rules we do have to protect the health of the public?
I can't speak to all the environmental laws that you mentioned, but I do agree about OSHA and the other federal agencies that you mentioned, although the Consumer Product Safety Commission may see increased recalls as they have already with E10 for some of the non-road engines.
But that would be actually a statement in support that we're not depriving the Consumer Product Safety Commission of their part in evaluating the market.
I'm not aware of any preemption.
Great, thank you. I got 47 seconds. Mr. Deneen, you say in your statement that the current regulatory structure provides no pathway to certify existing equipment for anything other than fossil fuels, even when test data demonstrates its safety. Can you elaborate on that?
Yeah, right now, if you've got an underground storage tank and a new fuel is coming into the marketplace for a new fuel blend like E15, Underwriters Laboratory does not recertify existing equipment. So even if you were to go and you were to demonstrate that there's a plethora of scientific evidence suggesting that there's no safety issue here, you cannot meet the regulatory burden. This bill provides a pathway to do that.
Yeah, and if as former Speaker Hastert couldn't get UL to at least address this issue, how can anyone do that? So I thank you. I yield back my time, and I recognize Mr. Green for 5 minutes.
Thank you, Mr. Chairman. I apologize that having known Mr. DeRiva for many years and worked with him, I'll not refer to you as Charlie, but let me clear up something before I ask questions. In your testimony, you compare the immunity protection in this bill to protections afforded to the pharmaceutical companies for vaccines. However, the National Vaccine Injury Compensation Program did not eliminate the liability. It created a no-fault system for patients injured by vaccines. So to be clear, it's a guaranteed injured people the right to some recourse, unlike this bill, which provides nothing to injured consumers. Is that, I think we're comparing apples and oranges, or maybe even apples and refined product.
Well, I think, Mr. Green, we have to be certain that when a fuel or fuel additive is entered into the marketplace, it affords the same protections to everyone. Yeah. It affords the same protections to the consumer, whether it's a 1995 automobile or a 2011 automobile. Yeah. It affords the same protection to a off-road vehicle, a handheld power equipment, a motorboat, or a snowmobile. In the testimony, we compare it to that in the fact that the pharmaceutical folks have a series of things they go through, and that particular thing is absolutely government approved. Now, it may have something else in the marketplace or an individual kind of reaction. What we're looking at is stop the bifurcation, stop the trifurcation of EPA, and make sure that all equipment is safe. Use E15 or higher blends safely for all concerned. That's what we're talking about.
And I know, but there is a difference between what we did with pharmaceutical and vaccine immunizations, what the bill does. I would like this bill to do what we did for the pharmaceutical industry, because believe me, I want not only refiners, and I'm proud to represent 5 of them, but also my retail outlets, because you're doing what the EPA tells you to do, and you shouldn't be held liable, but there ought to be someone there, and if the federal government ought to be the one doing it.
Well, and I could agree, Mr. And the ultimate, I think we can agree, the ultimate goal here is to protect the consumer. We're not trying to make an end run around any consumer. We're trying to protect the consumer.
You know, if a consumer with a or 2000 vehicle shows up at a station and fuels, and that fuel's bad, then because it doesn't fit that particular engine, you have to admit, I'm not a big fan of E15, and Mr. Deneen understands that. But be that as it may, I understand refiners and retailers are concerned about the liability damage from E15, and I share your concern. That's why I've co-sponsored a bill that 523, which was introduced by Mr. Gonzalez. As I mentioned in the statement, since the use of renewable fuels mandated by federal law, 523 says the government should be responsible for any liability, and 523 is targeted for that response. But the bill before us today is entirely different. It goes far beyond just E15. It goes far beyond harm to equipment and engines, and lets individuals end up absorbing the cost of anything. Ms. Baker, Brandstetter, what are some of the problems that vehicle or equipment owners may experience with E15?
Well, in the non-road engines, lawnmowers, trimmers, anything that requires gasoline, there could be corrosion in the gas tank.
I bought a new motor at Sears last month, and that's a new lawnmower. It could not be used E15 even though it was bought in 2012.
Right. It is not, E15 is not approved for use in that appliance.
So we're going to have to be able to buy our gas somewhere else from another pump from one of the convenience stores.
Yes, and it's very expensive to buy pure gasoline. Sears does sell it, but it's about $24 and up per gallon.
But we can use E10 now
Correct.
in our lawnmowers.
I think that's an important point. Small engines do certify and warranty E10 for use in those vehicles. And an important distinction, E15 is not being mandated. It could be an option for those consumers that have a 2001 and newer vehicle and want to use it because it's appropriate for their
So
car
are we
and their
going to be
wallet.
able to have an E10 and E15 pump at the convenience stores? Is that really possible?
It's most likely that you're going to have a few markets where E15 is even going to be available.
Well, I'll give you a good example. I'm 30 seconds left. The only place I can find anything but E10 in my district is at a Kroger store, and that's because GM made an agreement with them to market ethanol. But in my area, it's really difficult to find ethanol, even though I drive a flex fuel vehicle. And so that's my problem. And because we're an oil and gas area, and it's just difficult to get the renewables. Now, we could debate MTB all day because I lost that battle in '05, but we used to make MTBE in our district. Now we still make it for export, but not near as much as we used to. But Mr. Chairman, I know and Charlie, I'd love to, but I'm running out of time. In fact, I'm over time. So,
Gentlemen's time's expired. You're welcome to Southern Illinois. I'll show you where all my E85 stations are, and we'll get past this E15 debate.
and I'll take you to any refinery I got.
So we're going to recess this hearing, and we have 3 votes on the floor, which means, what, about an hour? 45 minutes to an hour, so you can take a break, stretch your legs, get some coffee, and we'll reconvene after votes. The hearing is recessed. To order, and would now like to recognize Mr. Whitfield for 5 minutes.
Thank you very much, and I also would like to thank all of you for coming and testifying on this legislation today. I was listening to your opening statements and the comments made by Mrs. Brandstetter and Henry Waxman and others, and so we find ourselves in a situation where we have this federal mandate on the renewable fuel standard. We have EPA with responsibility of administering the renewable fuel standard. We have EPA issuing regulations to mitigate liability in certain situations, and yet, as Ms. Brandstetter pointed out, we do have a situation where cars that are older than a certain year, you can't put E15 in it without damage, and small engines, lawnmowers, so forth, we have that. So we have this liability problem. We have a liability problem where people, through no fault of their own, can accidentally have this fuel put in, and they're going to suffer some damages because of it. So then the question becomes, well, who really is responsible for that? And in some ways, you can say, you know what, the federal government should be responsible for it. So I just want to toss out a thought that I had, which may not have any merit at all, but under the Clean Air Act, before they had the Equal Access to Justice Act, which, as you know, under the Equal Access to Justice Act, the legal fees are paid by certain plaintiffs who bring actions under the Clean Air Act. And then also, the Equal Access to Justice Act actually pays some of the damages in some situations. So you could almost make an argument here that we could extend the ability to have access to the Equal Access to Justice Act under the Clean Air Act for people who, end up suffering damages because of this federal mandate, because of federal regulations, and through no fault of their own, they end up suffering damages for their motors or their vehicles. And I was just, this may be so off the wall, but I'll just ask you if you have any comments on that or thoughts on that. Now, John Shimkus and I, Mr. Chairman Shimkus and I and others have really been upset about the Equal Access to Justice Act because it lacks transparency. We never really know how much money is being paid out. But if there was ever a time, most of that money goes to environmental groups and others who want to enforce the Clean Air Act when they think EPA is not enforcing it. Here we have a situation where you have citizens suffering damages that they had no responsibility for whatsoever. And why should they not have access to that fund? So do y'all have any thoughts on that?
Congressman, I'll wade into it because I don't hear anybody else stepping up. I am not an expert on the Equal Access to Justice Act, but in terms of the premise of your question, and I can't speak for other fuels or fuel additives,
Yeah.
but at least with respect to E15, I don't think that there is any data anywhere that would suggest that one act of misfueling E15 into a pre-2001 vehicle is going to cause damage.
Okay.
EPA took the action that they did, I believe, in an abundance of caution, because there wasn't sufficient data out there for older vehicles. It's real hard to test over the useful life of an engine a fuel in a vehicle that is that old. You can't find vehicles to test.
Yeah.
And so they didn't have appropriate test data. Now, higher blends of ethanol than E15 are used elsewhere in the world with no problems whatsoever.
Okay.
Brazil, as everybody knows, uses a blend of E25.
Okay.
So I don't think that one act of misfueling anybody would suggest would cause damage that anybody would have to seek redress for.
Okay. Well, I'm certainly no expert on it. I was just reading Ms. Brandstetter's testimony, and I sort of came to that conclusion. So, anybody else have any comments? Yes.
Mr. Whitfield, again, I'm no expert on that provision or that particular act. I think the focus, as the bill we're talking about today, is focused on not only protecting the supply chain from lawsuits, but I think we should also be focused on protecting the consumer. And I guess my agreement, or at least Mr. Deneen's agreement with me, has been short-lived, but that there's a reason why Congressman Sensenbrenner had letters delivered to him by the automakers, and I think we're letting the theory go. I think it has to be addressed. We're talking about 2,000 vehicles backwards to 1999, whatever. And I agree there's not that many out there, but there's a reason why those automobile manufacturers said they will not warranty anything over E10. There's a reason why the marine manufacturers say they will not warranty anything over E10. There's a reason why the outdoor power equipment people say they will not warranty anything over E10. So, I mean, there's a, it's not because they're trying to, avoid any warranties. It's because they're trying to tell the consumer, be careful, let's not do this. We haven't had enough testing on this stuff yet. So, yes, we fully support this bill. And as long, as I said earlier, as long as the RFS, with its ever-increasing mandates for increased renewables blended into gasoline, is the law of the land, that I believe just not only refiners, but everyone down the supply chain has to be protected. But I also agree. I also believe that the consumer ultimately has to be protected, and it can't be on some 4x4 little thing on a pump that says. I mean, I'm quite surprised at EPA itself, that when in the history of EPA has compliance with a major environmental law ever been placed on the consumer? And that's what they're doing.
If I can make one quick comment, I don't know anything about the Equal Access to Justice Act, But this legislation is not talking about the procedures that EPA goes through to set certain rules. It is, if we want to talk about EPA not doing what they're supposed to do, that's a different topic. Right now, we have a process in place. We have rulemaking, we have comments. I don't think the three of us agreed on what the misfueling label mitigation measure should be for E15. EPA made a decision. If we don't like the decision process, let's talk about that in another forum. But once a decision's made, we have to have something to rely upon. We have to be able to live under the rule of law, and that's what we have right now.
Gentleman's time expired. Now just take a brief second. And that whole diesel story I gave to, as a prelude, well, you can't do that anymore because they retrofitted the nozzles, and you cannot. And the reason why I know that is I was about to do it one time. Here I was blaming staff. Now I can blame, and the system caught me. So now I'd like to recognize Mr. Lotta for 5 minutes.
Well, thank you, Mr. Chairman. Actually, that's leading right into my question about your situation with that diesel. And, you know, late at night, as members of Congress are at home, we put a lot of fuel in our cars. And there was one time I actually picked up the diesel nozzle, and I looked at the ends and said, well, at least I couldn't have put it in to the car at that time. I would have been in big trouble like you had a while back. But if I could ask Mr. Eichberger this question, how common is it for people to maybe miss fuel when they're at a pump?
Well, I mean, right now there's not a whole lot of that happening because most dispensers have 3 grades of gasoline dispensers, usually on a different nozzle size, sometimes a different dispenser completely. E85 is typically at a different dispenser and very clearly marked and labeled. Right now we don't have a whole lot of incidents of that occurring.
Let me follow up then. Do you believe that the posting of the legally required notices would deter a lot of people from using the wrong fuel when they're at the pump?
It will deter some. It really is going to come down to what is the price differential. And unfortunately, consumers are sometimes willing to take risks with their vehicles in order to save a couple pennies at the pump. The decal requirement, and keep in mind this decal is about 1.5 times bigger than any other decal identifying fuel identity on the dispenser, has to be put right on the selector area, so you will see it. You cannot push an E15 button without seeing an E15 sign. So you're going to be well informed. Some people will say, you know what, it's 5 cents cheaper, I'm doing it anyway. And that's just the reality of it. Consumers, when we were going from lead to unleaded, leaded gasoline was less expensive. We had nozzle size restrictions like on diesel fuel. People who took can openers and pried open their fill pipes or stuck funnels in their cars to put unleaded fuel in their leaded cars, or leaded fuel in the unleaded cars. EPA fined retailers for that action. That's why we are so concerned. No matter what EPA does in terms of misfueling, a customer who wants to misfuel will find a way to misfuel. And the retailer cannot prevent that independent action, just like we couldn't prevent people from manipulating their vehicles in the 80s to put leaded fuel in unleaded cars.
Will the gentleman yield for 1 second?
Are you the chairman?
Yeah, just to make a point, where we have E85 pumps all over southern Illinois, you do have individual citizens mixing at the retail location. So they may fill half their tank up with E85 and then the other half with regular gasoline. So what's the litigation issue there? And who is blamed for a process when it was the individual consumer's conscious decision to mix at the pump? And that's kind of part of the reason why we've been talking about this.
Well, thank you. If I could just kind of continue on that line of questioning, you know, what equipment would have to be replaced when we're talking about, you know, most of the pumps I see, you've got 3 grades of gasoline. If you don't have the ethanol right there, or a diesel, you have 1, 2, 3, and if you're talking about another, you know, with the E15, I assume you'd have to put in another pump, and then you'd have to put in more tanks. Could you fill me in on that?
Well, each retailer will have to decide how they want to configure their station, assuming the equipment is compatible. And that's a big assumption, assuming you have compatible equipment. Most retail stations have 2 underground storage tanks, a regular and premium. We blend through the dispenser to blender pump to give you mid-grade. In order to offer an E85 or an E15 mix, we would have to dedicate one of those tanks to either an E85 or a higher grade ethanol blend in order to get that product. That would likely lead to us reducing our overall gasoline offer by a full grade, unless we have room to put in another tank. Now, there are some places where you don't have the room, you can't get the permitting. Putting in a tank can be expensive. There's a retailer in California wanting to put in a diesel tank. It's going to be $200,000 just to put in a 6,000 gallon tank. So you look at retailers are making $35,000, $40,000 a year in pre-tax profit. $200,000 for installation is a pretty hefty bill to pick up.
And, and also just follow up with my last 39 seconds here. Without the legislation, who would be liable pretty much if an individual puts that incompatible fuel in there? That's the big concern out there.
Under the Clean Air Act, the retailer could be fined $37,500 per day for each incident for allowing their consumer to do that. And so the liability could fall directly onto the retailer for the independent action on the consumer.
Thank you. Mr. Chairman, I yield back.
Gentlemen, yield back at time. Chair now recognizes my colleague from California, Ms. Capps, for 5 minutes.
Thank you, Mr. Chairman. And thank you, each of you, for your presence here today and your testimony. In my congressional district and across the country, the effects of MTBE contamination have been significant. Cities like Cambria and Oxnard on the Central Coast of California have lost their public water supply sources, and homeowners have lost their private wells. And so many have learned through personal experience, when fuel containing MTBE leaks from an underground storage tank, the chemical travels quickly through the soil into sources of drinking water. It makes the water foul-tasting and undrinkable. Studies suggest that it causes cancer. It's very expensive to clean up. According to drinking water utilities, the total cost to clean up MTBE contamination of public water systems in this country could be as high as $85 billion. Cities and towns in my district are still seeking to recover their cleanup costs from the oil companies that caused the contamination. If this legislation passes, its liability shield will halt those lawsuits and leave these communities, some in my district, with MTBE contaminated water supplies stranded with billions of dollars in cleanup costs, while the companies that created and distributed the product may pay little or nothing at all. Mr. Brooks, I'd like to direct a few questions to you. Can you tell me about the costs and difficulties your state of New Hampshire has faced with MTBE contamination?
Thank you, Representative Capps, for your question. It's been a significant concern. Again, our lawsuit alleges that to actually find and clean up all of the MTBE in the state, we're talking easily in the hundreds of millions of dollars. Already, through various funding mechanisms, we have spent, depends on your estimate, but overall for gasoline, hundreds of millions of dollars, and a significant portion of that for MTBE. As you've said, MTBE costs more to clean up than other contaminants. It travels faster, it stays longer, and it costs more money. So we have additional costs, and these costs aren't going to go away soon because it is a long-lived contaminant. In New Hampshire, we have different kinds of aquifers. We have some stratified aquifers, which is essentially sand, but we also have a lot of bedrock with fractures. MTBE gets in a fracture, you cannot tell where it is or where it's going for many, many years, and it will still be there. So we're talking about a significant cost.
Do you believe that New Hampshire citizens should bear these costs of cleaning up pollution?
No, I was gratified to hear that it seems to be a fundamental theme of many people on the committee that people who are harmed need redress, and that's a fundamental principle for us as well, is that someone who has done nothing wrong. And we've talked about some instances of someone who puts fuel in their tank, possibly having some behavior or warranty voided or something like that, and that's certainly a concern. We have many instances where the person wasn't involved at all. They're a homeowner. They might be several hundred feet away or more from a convenience store. Their property, their home, which is something we consider sacred in New Hampshire and other places, has been affected, and they need to have redress.
New Hampshire, is not alone in its concern about this legislation. The Association of California Water Agencies is very concerned about this bill and has sent a letter asking us, I think it's already been held up by our ranking member, asking us to ensure that these lawsuits are not dismissed. As they point out, this bill will further strain communities already struggling with the cost to repair aging drinking water infrastructure and further burden ratepayers in those communities. Do you agree, Mr. Brooks?
Yes.
The California Water Agencies ask us, and I'm quoting now, to ensure that no local community or drinking water system will be left without the ability to recover costs associated with remediating MTBE or other similar contamination of drinking water sources. Is that a position with which you would agree, and perhaps you speaking on behalf of the state of New Hampshire?
We do, and it's very important for a state like New Hampshire that has a rural character. We have only 1.3 million people. 200,000 private wells supply drinking water to the people of New Hampshire. Those people don't have the ability to spend a lot of money to clean things up, and certainly don't have the ability even sometimes to sue for redress. So very significant that that type of community has the ability to do what they need to do.
Thank you. We've already heard today that this legislation will be redrafted so that it is no longer a liability shield for MTBE. If this bill is amended so that MTBE is not covered, will you still be concerned about your state's ability to recover costs when contamination from other fuels, the next MTBE, if you will, and fuel additives occur in the future?
We would be concerned any time where someone has been harmed, especially wrongfully by the conduct of another party, where they could not seek redress. So we would want to make sure that someone has some means for compensation if actually they have been harmed.
Thank you. I share these concerns, and I urge this committee to heed the requests of those water agencies to make sure that communities are not left without the ability to recover costs when polluters contaminate their water supply. I yield back.
Gentlelady yields back her time. Seeing no other members, I can ask Mr. Green, do you have anything else you want to add?
Oh, Mr. Chairman, we could probably talk all day and let Charlie and Bob talk too, and maybe but I appreciate you doing this legislative hearing. I know we were just talking, and I said it publicly. There's a solution that we need to do this, because both from our refiners and our retailers, and hopefully we can work together and come up with a plan.
Seeing no other members, this hearing is adjourned.